deep honor, I welcome His Lordship, the Chief Justice of the Democratic Socialist Republic of Sri Lanka. I would like to express my gratitude and warm welcome to our erudite keynote speaker, Professor Benjamin Sonthal, Professor of Buddhism and Asian Religion, Director, Otago Centre for Law and Society, New Zealand. An eminent scholar and well-respected international academic in the field of philosophy, law and policy. It is our pleasure, privilege, and we are fortunate to have you as our keynote speaker today. Sir, on behalf of the Faculty of Law, I would like to take this opportunity to express my deep appreciation to you for accepting our invitation to be the keynote speaker at the Annual Research Symposium of the Faculty of Law, University of Colombo. It is with great sense of pleasure and pride I welcome Madam Vice Chancellor, Senior Professor Chandrika N. Vijayaratna for this event. I would like to take this opportunity to express our sincere thanks and deep appreciation to you, Madam, for honoring us with taking the time time from your busy schedule to be with us today. I would wish to recognize our Madam Vice Chancellor's encouragement, guidance in organizing this symposium, and her unwaning support to the Faculty of Law in all endeavors. I am happy to acknowledge her admirable effort that you have taken in promoting research culture, research and innovation culture in this University of Colombo. I wish to extend a special welcome and express our profound gratitude and appreciation to all our distinguished invitees for accepting our invitation to join this virtual event with us. The Faculty of Law, being the premier seat of legal education in this country, shine as a luminous legal light in the context of law, order, justice, and jurisprudence. This symposium is a part of the University Symposium, which has been held across all faculties of the University of Colombo to showcase and highlight the research being done at the top-ranking university in this country. Our symposium theme, fascinating symposium theme of this year is impactful legal research through interdisciplinary approach. In embracing the university vision to bring in interdisciplinary approach, the law faculty has envisioned this topic, this theme for our annual research symposium. I believe that this symposium will provide a platform to share knowledge and expertise and critical review of issues leading to define goal for our profession. I'm sure that today's discussion is going to be busy and productive, revealing exciting new insights, ideas and views, and I'm certain that the papers presented today cover a broad spectrum of areas in the field of law. They will reveal and offer exciting new insights and expand the horizons of knowledge in the field of law. This presentation will no doubt help all of us to rethink, revisit some of the traditional wisdom that we have held so far and enable us to appraise them from different legal and other angles. It is unique this year that the law faculty has developed a set of policy recommendations empowering the policymakers of this country to revisit and revise the legal system of this country in line with the university emphasis of envisioning or embodying the SDG goals. Our faculty has compiled and submitted the distilled research findings to our policymakers, and you can see at the in the course of the day how the faculty has contributed in this regard. I would like to take this opportunity to commend and thank the faculty staff, the organizing committee headed by Madam Professor Indira Nanayakara, the Symposium chair, for this diligent work, for the dedication and commitment they have shown to make this occasion possible today. I'm grateful to Professor Indira Nanayakara for her effort in making the symposium a reality. As you know, this academic research symposium is the dissemination of knowledge. And I invite you to enjoy the intellectual feast hosted by the Faculty of Law in the technical sessions. I'm very proud to announce that at this very important occasion, the law faculty will launch its Sri Lanka Journal of International Law, the latest volume, and it is the flagship publication of the Faculty of Law. I thank the editors and all the contributors in this endeavor. In conclusion, once again, I wish to thank you for being with us today and wishing you a most fruitful, dynamic, and productive time, hoping that you will take away new insights that will be of use in your career, practice, and studies. With these words, I thank you all and wish you every success.
Thank you, sir. I would now like to invite Vice Chancellor of the University of Colombo, Senior Professor Chandrika N. Vijayaratna, to speak a few words.
Thank you, and I bow one. A very good morning to you all. Honorable Chief Justice of Sri Lanka, His Lordship Jayantha Jayasuriya, President's Council, Honorable Attorney General, and all the honorable judges of the Supreme Court, the Appellate Court, and all other institutions. Keynote speaker, Professor Chantal from New Zealand. I'm sure it is a very good afternoon to you, Professor Chantal. Dean of the Faculty of Law, as well as the former deans, Conference Chair, Professor Indira Nanayakara, all the alumni, the respected alumni, the heads of departments, the academic, administrative, and non-academic staff, and dear students, both postgraduate and undergraduates from the Faculty of Law. Thank you ever so much for inviting me for which has been a series of annual research symposia of our 9 faculties, campus, as well as many institutions and departments. And I thank the entire Faculty of Law for collating all your research conducted in the last 2 years to also with the university's overall theme of addressing impactful research through an interdisciplinary approach, which I think is extremely timely. And I know that you have very important recommendations made to be reviewed by the policymakers, which we will present through the UGC to the Parliament of Sri Lanka, as well as other relevant institutions. So I would like to, at the outset, congratulate you, as well as highlight the fact that we, as a responsible university, a pioneering university, has to actually address not just knowledge transfer, but knowledge creation through research and innovation. And in this respect, I'm extremely touched by the response of the law faculty, not only with respect to collating and disseminating the research, but also engaging with the central administration in addressing new issues that came up when we went onto a virtual mode since the COVID-19 pandemic. And particularly in terms of the problems we face by connecting up virtually in terms of cyberbullying and other aspects. So I would like to place on record that your faculty has been an enormous strength to our university. It adds glamour as well as quality, which I'm sure will help to take our university further forward in local, regional, as well as international recognition. From the perspective of addressing appropriate themes, appropriate to the 21st century, I'm also very grateful to the Faculty of Law for addressing intellectual property rights, particularly from the perspective of research and innovation and commercialization, as much as upscaling and highlighting the importance of addressing the Sustainable Development Goals, and particularly through the Center for Human Rights, which has reached 30 years. So I'm sure you all will all have extremely useful discussions and engagement, which will not only give us recommendations, but also give new ideas for newer research, which I think is the way forward. So thank you very much for addressing these aspects, and also for garnering the students who need to get into that mode of learning rather than waiting to be taught, as well as I know that the alumni are going to help us to take the aspect of English for law further forward, so that we would ensure that every student is well equipped to face the world of the 21st century, and also through the virtual mode. So thank you very much. Stay safe and enjoy the proceedings.
Thank you very much, Professor. Next, we have the address by the Chief Guest. I would like to invite our Chief Guest this morning, Honorable Chief Justice of Sri Lanka and President's Counsel, Mr. Jananda Jayasuriya, to deliver his address.
Good morning to all of you. Senior Professor Madam Chandrika Wijeratna, Vice Chancellor, Dr. N.S. Puncheva, Dean Faculty of Law, Professor Indira Nanayakara, Chairperson of the Symposium, Professor Vasanta Senaviratna, today's keynote speaker, Professor Benjamin Sonthal, dear participants, other distinguished invitees, professors, members of the student population, all other distinguished participants. First of all, I must thank the Faculty of Law for giving me this opportunity to join with you all this evening at this important event, and to see how best that we could achieve our targets, even though that we all are seriously impacted due to the COVID pandemic. So I should congratulate for taking all these endeavors to reach all participants and all interested parties in this endeavor. The topic that you all have decided to discuss today, or the theme, is very timely. It touches on research, and that research to be impactful and also to maintain the interdisciplinary approach. These three key areas are really important in today's world. We all know the importance and the significance of research. And in today's context, we know that the technology's development had given the mankind to reach any part of the world within seconds. So that has advantages and disadvantages as well. So communication of correct perspectives, correct knowledge, proper knowledge, and also the proper analysis is very important. Misleading opinions and deceitful opinions can cause immense harm to the entire society. So if the research to be credible and creditworthy, you know, the resources that you all would be relying on. So it needs to be impactful, and it would be impactful if it reaches the necessary parties. I'm happy to hear that the endeavors that you all have taken, without confining the results of these researchers to the academia and the student population, to take it to the next level. So I don't intend taking much time at this opportunity, but it's a great opportunity for me to join with you all. And also, so I would to congratulate again the Faculty of Law in all their endeavors during these difficult times to ensure that what you all would have achieved in normal circumstances would not be impacted, but we will continue with all your endeavors to the best of possible ways. So congratulate all of you and wish you all a good symposium. Thank you.
Thank you, sir, and thank you for being here with us today. We now have a presentation of a token of appreciation to our chief guest by the Vice Chancellor of the University of Colombo.
Library here and at the Center for the Study of Human Rights. I've been the recipient of extraordinary hospitality from faculty members, among them Professors Edrasinghe, Scarneville, Tamamaran, and Dialvis, and others. And I have particularly fond memories as a graduate student of joining Professors RKW and Savitri Gunasekara at their house for tea when I had some questions about fundamental rights when I was a graduate student, and they were very, very gracious. And indeed, let me also say that much of my work, much of my research sits on the shoulders of the giants, the scholarly giants who wrote from the law faculty at the University of Colombo, Jennings, Tambaya, Nadaraja, and others. And so many of my close friends and lawyers and scholars whom I admire seem to have taken their degrees from you. So I somehow feel like a cousin or a relative once removed from the law school. Now, before I get started today, I also want to acknowledge the very challenging times that you seem to be facing in Sri Lanka. And many of you, I expect, at the moment are doing it tough. And I want to say that I'm following events and I'm thinking of you. And given all the challenges, I especially thank you for your time and attention today. So let me move to the talk. I'll just share the screen here. And perhaps someone could just give me a nod that they can see the screen there. Yep. Okay. So there's a famous saying in journalism, and perhaps you've heard of it, that the best reporters don't just give you their opinions, they, quote, cover the facts. And not just any facts, but the facts elicited from asking 5 questions, known as the 5 W's. Who, what, where, when, and why. Now, this kind of thinking is not entirely unfamiliar to legal professionals. They too are interested in 5 W's and pursuing a particular set of facts. Those facts appear, among other places, in the headnotes of legal cases. Consider, for example, this slightly redacted headnote from what I consider to be one of the more interesting court cases to take place in Sri Lanka over the last 50 years. Answering the question of what happened, the headnote tells us that the case involved a Buddhist monk and the question of whether he could be enrolled as an attorney at law. It also tells us something about what the relevant laws are. In this case, the Administration of Justice Act and the religion clauses of the Constitution, the 1972 Constitution in this case. The headnote even tells us briefly what happened. Namely, a group of petitioners sought to prevent a Buddhist monk from being enrolled as an attorney at law, even though that monk had fulfilled all the requirements for so doing, including completing a law degree at your fine institution. The headnote also answers the who question. It tells us something about who was involved. We have the name of the monk, the petitioners, and the list of judges and lawyers who acted. Answers to the question of where and when also appear here. The where is the Supreme Court, a setting that communicates both a geographical and an institutional location. The when are the dates of the hearing. Headnotes like this even answer the question of why. Namely, why was the case decided in this way? Providing not only the points of law and fact that were affirmed in the opinion, but even listing the previous cases to which the judges referred. There's a reason that these details are set apart in court reporting and placed for easy reference in the headnotes. That's because legal professionals consider these particular facts to be especially important. In other words, unless you're directly involved in the case, these are the 5 W's that are truly worth knowing. Learning to read cases in this way is a large part of what goes on at law schools. Moreover, it's a skill that's essential for legal professionals, those operating on the inside of law. What does it mean, though, to train students not just to be legal professionals, but scholars of law, observers of law's role in the world? What is the difference between what goes on in the law college and the law school, and between our systems of professional knowledge and our research institutions? I would humbly propose to you today that as researchers of law, we must push beyond the head note. We ought to question our questions and rethink the facts that we consider relevant. We ought to approach the law not simply as a technology to be used, a craft to master, but as a much larger feature of our society, such that in order to truly understand it, we need to widen our focus and broaden our methods. That is to say, I believe the work of a legal researcher differs from that of a legal professional in that the researcher must think beyond the inside of law, beyond the normative universe of legal institutions, and beyond the world of headnotes, judgments, and statutes. The researcher must also look at the outside of law, law's life in the world. Unlike legal practice, this kind of scholarship requires that we think not only about what the law says, but about how legal principles and court cases actually function in society, how laws influence literature, politics, and many other aspects of everyday life, and how these aspects of everyday life influence the law. Doing so requires that we momentarily put aside or bracket off the professional habits of thought, modes of inquiry, and deferential disposition that is cultivated, even required in the practice of law as a vocation, and to look again critically, objectively, at the complex human mechanics that shape the way laws function in the world. In this talk, I want to nudge us a little bit further in this direction by looking again at the 5 W's, not through the lens of a lawyer, but through the perspective of a socio-legal scholar. What? It seems like a rather obvious question, but what is the law in Sri Lanka? Clearly, when we talk about the law, or the so-called rule of law, we're talking about a very particular thing, namely systems of regulation recognized by the state, such as constitutions, statutes, or legal decisions. In some cases, such as the Sumana case, the what of law also extends to one of the systems of customary or personal law that are recognized as special laws in Sri Lanka, including Muslim personal law, Desavalame, Kandyan law, or in this case, Buddhist ecclesiastical law. But does the what mean anything more than that? John Griffiths, the well-known sociologist of law, once referred to the official recognition of customary law, like Sri Lanka's special laws, as the weak version of legal pluralism. It was weak, he said, because it gave the impression that customary laws were like many versions of state law, bounded, uniform, hierarchically organized norms that were simply waiting around for sovereign recognition. This, he contrasted, with the strong version of legal pluralism, which he saw as the real condition of law in society, law as it was experienced by humans. In its strong form, legal pluralism was not an orderly world of neatly separated jurisdictions, but more like a nebula of norms, all mingled together. Think for a moment about the various legal orders operating for all of us right now. Yes, we're engaging with certain features of state law, but we're also embedded in many other normative orders, professional codes of conduct, and protocols of etiquette. We are constrained by cultural rules and perhaps moral or religious injunctions. These systems for Griffiths don't stay tucked away in their own little jurisdictions, religion at home, professional ethics at work. Rather, they all act on us at once, sometimes aligning, sometimes colliding. It's legal pluralism in this strong sense that gives rise to the Sumana case in the first place. The group of Buddhist organizations who opposed Venerable Sumana's application to the bar did so in response to a presumably religious imperative, a rule of Buddhist law. In asking what is the relevant law, therefore, it's not enough simply to point to the national laws, because an entirely different legal system seems to lay at the core of the matter. Not state rules about applying to the bar, but Buddhist legal notions about proper and improper conduct for Buddhist monks. But what exactly is Buddhist law? If one applies the same spirit of investigation to Buddhist law as I have just applied to state law, it's clear that Buddhist law also has weaker and stronger versions of pluralism. The weak version, to which parties in the Sumana case seem to appeal, portrays Buddhist law as an orderly, coherent system of norms contained in a single text, the Vinaya Pitaka, the canonical code of Buddhist monastic law. Yet considered sociologically, historically, the text of the Vinaya is not singular. The Pali Vinaya, which Theravada Buddhist monks observe, is one among three distinct versions of the Vinaya Pitaka that Buddhist monks use in the world today. Chinese monks follow the Dharmaguptaka Vinaya. Tibetan monks follow the Mula Sarvastivadin. Moreover, the Pali Vinaya is one of 18 separate Vinayas, which are thought to have existed historically. And the Pali Vinaya itself is a sprawling and complex text, consisting of three rather different parts: a list of primary rules in the Sutta Vibhanga, a complex set of procedural regulations in the Khandaka, and a short, terse summary of the key principles in the Padivada, which was likely written sometime after the first two. Yet the strong pluralism of Buddhist law doesn't stop just there. As it relates to the history of Sri Lanka, the Vinaya has not been the only source of Buddhist law. There are various commentaries, sub-commentaries, digests, and manuals that have shaped monastic behavior. Especially important have been the various monastic constitutions, or katikava, that have been produced from the late first millennium onwards. Although these laws claim to condense relevant Vinaya rules, katikava do not simply reiterate older norms. The authors of these texts describe their work as updating monastic law, quote, according to the times, kala anurupa. And the contents of katikavata combine direct phrases and ideas from the Vinaya with those taken from other sources, such as commentaries and suttas, or even royal and state laws. Over the last few years, I've been fortunate to locate and read nearly 24 of these texts. And if you're interested, I've published some sort of initial findings about these katikavata in a couple of journal articles, which I'm very happy to share with participants. I can send them to Dr. Punchi Hewa if people are interested. Now, reading these katikavata, one can see clearly different strands of Buddhist legal thinking. Some katikavata forbid monks from participating in politics or legal cases. Others say nothing at all. Even the most basic rules taken from the Vinaya can be recruited into vastly different interpretations of Buddhist law. Consider the various interpretations of this ostensibly clear Pali phrase, Pabajen to pisodetva, pabajeta sodetva, upasampadadeta. Should be, there's an error there. And this means, ostensibly, having examined the ordinand, give lower ordination. Having examined the novice monk, you should give higher ordination. The phrase appears in a majority, if not all, of the katikavata I have read, and its origins could hardly be more orthodox. It comes from the Samantapasadika, the major Pali commentary on the Vinaya, written by Buddhaghosa in the 5th century. Yet there are vast differences in how authors of katikava choose to interpret this phrase. Here's one that appears in a katikavata written in 1842. Because this is said, namely the Pali phrase, because it is said, children of good families, Kuladaruvam, must not be ordained without the permission of their parents, even those who become a monk hundreds of times, because again, they keep giving up robes and going back to the life of a householder. For each of those 100 times, the person may only be ordained if the parent's permission is obtained. Also, those Kuladaruan should be ordained only after they understand clearly the letters written by their teachers, including all 10 types of consonants. These authors interpret the phrase having examined, sodetva, to mean that the preceptor will examine whether the novice has his parents' permission and whether he knows how to read and write. Contrast this with the following interpretation contained in a katikavata from another fraternity at the turn of the century. Because such things have been said like this, it means that when boys come to you wanting to ordain, you should first examine their caste, family, and clan, jati, kula, gotra, and consider whether they are well-behaved or poorly behaved, capable or incapable. Only those well-behaved sons of good families, who are jati kula putriyan, should be ordained, By not doing this, there will be no development in the sasana because people will ordain for reasons of land or property, or for some other kind of profane reason. A candidate for the monkhood that received ordination should be taught the meanings of contemplation, the haranasika, that's the sort of rules of novice monastic life, the daily monastic duties, the 4 bases of meditation, the Sakya rules, and the Pirit verses before he is ordained. As you can see, in this case, the same short Pali phrase legitimates a range of other rules about ordination, including restrictions on jati kula gotra and requirements, very specific requirements, for preparatory study. Now, I could go on and on for hours about these kinds of things, and I think some of you may find it interesting, but I would surely go on for too long. I'm endlessly fascinated by Buddhist law, and I'm currently in the process of trying to finish 2 books on the topic. But for the moment, let me simply highlight a very basic point. It's the cascading levels of complexity that, sociologically speaking, come when we ask the question of what is law, or what are the relevant laws. Stepping away from the head note paradigm, the substance of law, the what, appears much broader on the outside than it does on the inside of law. Yes, it entails state law, which itself acknowledges legal multiplicity to some degree. But sociologically speaking, these are far from the only laws of relevance. There are also other normative orders that interact with and motivate state law. And even those normative orders are not singular, but plural, not hierarchical, but overlapping with each other. To approach law from the perspective of a social scientist rather than a legal professional is to be sensitive to how we're thinking about the scope and substance of law, and to be aware when we do acknowledge law's plurality, whether we're thinking of it in strong or weak terms. Now, reconsidering the what of law is in many ways the most challenging step in reorienting our focus away from the head note point of view and towards a more expansive understanding of law in society. As one zooms out in this way, it becomes obvious that the story of law in the world implicates a much larger number of persons than first anticipated. Of course, those named in the head note are very important. Lawyers, judges, and litigants are among the most consequential figures, both in legal practice and in legal research. But here too, I would encourage you to think again, more broadly, about who the key actors are in a given legal event. Let's go back to the case of Venerable Sumana. Zooming out a bit, we can see that many more people are implicated in the controversy than the head note would have us believe. Some of this can be seen in the names of those who submitted letters of support and gave evidence. Prominent among those who supported Venerable Sumana was the well-known monk, Venerable Walpola Rahula, who happened to be a senior figure in Sumana's own monastic group. Although Venerable Rahula is famous today for his philosophical writing on Buddhism, many here will know that for much of the 20th century, he was also a forceful defender of monks' rights to participate in politics. In the 1940s, Rahula was a key player in the development of the Vidyalankara Declaration, a manifesto drafted by monks of the Vidyalankara Pirivena, declaring their duty to participate in all domains of society, and rejecting attempts by UNP politicians at the time, such as D.S. Senanayaka and J.R. Jayawardena, to keep monks away from politics. For much of the 20th century, Vidyalankara monks, including Rahula and others, publicly challenged elite politicians and Buddhist lay organizations who wanted to restrict monastic activities to strictly religious things. Rahula's group argued that the Vinaya permitted monks to participate in things like political campaigns, salaried employment, and higher education. Looking at the Sumana case, one can see similar arguments and alignments playing out. The same organizations who petitioned against Sumana in this case had come into conflict with Vidyalankara monks like Rahula in the preceding decades. Taking a broader view of the who question then, one can see that the case of Venerable Sumana implicated far more than simply the bhikkhu and the petitioners alone. To understand the significance of Venerable Sumana's case sociologically, we also need to see how the case fits into broader struggles between larger communities of people. Not just Venerable Sumana, but the parampara of Vidyalankara monks more generally. Not just the petitioners, but the much larger group of Buddhist reformers who had been debating the terms of monastic orthodoxy since the 1940s. It is no coincidence, therefore, that in his very long, very interesting dissenting opinion, which opposes the idea of Sumana being admitted to the bar, Justice Vanasundara engages in a detailed, almost point-by-point criticism of Rahula's book, The Heritage of the Bhikkhu, Bhikshuage Uramaya. One might even spin the who of law further, though, to include many of the many newspaper editorials and popular commentaries about the case, many of which seem to interpret the events according to the political tidings of the day, in which the UNP was again emergent. Now, hopefully you can see where I'm going with this. Broadening the who question allows us to see the complex social embedding of legal events, the ways in which their causes, staging, and effects extend well beyond the actions of litigants, judges, and lawyers, and implicate much larger communities across time and space. Now, one might even extend this at great length. For my current project on Buddhist law, I was very fortunate to work with an experienced research team and conduct a large survey of nearly 1,700 bhikkhus to help map their understanding of Buddhist legal ideas, to get a sense for, what are the dominant ideas, what are the more marginal ideas, and so on. It was absolutely fascinating. But you can see that, if you want to extend the who of law further, you can even extend it to larger surveys. Okay. Where and when? This sociological approach to law, this kind of examination from the outside, also raises questions about the where and when of law. Where and when does law take place? Certainly, the event of litigation and the setting of the court is only one event in a much longer timeline and one episode among others. Consider, for example, the where and when of constitutional law. A few years ago, I published a book that offered a detailed history of one feature of Sri Lanka's constitution, its special provisions for Buddhism in Chapter 2, Article 9. In that book, I posited that we ought to think about the time of constitutional law, the when, in a particular way. I argued that we should look at constitutional provisions in a Buddhist way, as having multiple lives. In their pre-enactment life, constitutional clauses take shape as political agreements, often abstract and carefully worded so as to appeal to a broad electorate. In their post-enactment life, constitutional clauses serve as rules and principles for guiding a country's shared political future. Constitutional clauses have a societal life in which they're used as part of popular discourse, and a legal life in which they serve as technical instruments in official processes of litigation and regulation. One of the key points of my book is that constitutional law functions differently in these different lives. My book demonstrates how the very same prerogatives for Buddhism that were used to unite Buddhist lawmakers and activists during constitution making actually worked to divide Buddhists when those provisions were invoked in court. That is to say, vague constitutional ideals may have worked well as slogans in politics and society, but they have had the opposite effects when used as principles to adjudicate cases. In other words, the where and the when of law really matters. One can see this clearly in the Sumana case. Both the petitioners and Venerable Sumana argued that they were upholding Chapter 2 and protecting Buddhism through their actions. For Venerable Sumana, protecting Buddhism meant empowering monks and protecting their autonomy. For the petitioners, protecting Buddhism meant defending a particular version of monastic orthodoxy. By using Chapter 2 in litigation then, lawyers and litigants did the very opposite of what lawmakers had intended. Rather than unifying the sasana, they divided it. Now, the same can be said about other forms of law. If you want to understand law's work in the world, you have to think of its different effects in different settings and expand one's understanding of the where and when of law. This also means extending one's understanding of where law's records lie. As legal professionals, you're probably used to looking in particular places. Black letter sources, the official records of decided cases and ratified laws. And I'm guessing that today most of you look online. People like me remember, and many people here as well, the old days of having to look through books, but it's wonderful that you can just look at LawNet now. So these are the kinds of places that in your professional capacity, you're probably used to looking. But as legal scholars, I would encourage you to think of law as having a much larger trail of evidence and its record as being located in many more locations. Outside of these official sources, law's footprints can also be found in a variety of unofficial sources. Drafting documents and advocacy pamphlets, case files and newspapers, interviews and ethnographies, and yes, in temple libraries. In other words, it's not just where law takes place that matters, but where we look for its traces. If one were simply to follow the tracks of the Sumana case through its official archive, we might get the impression that the matter ended with the Supreme Court's majority decision, which allowed Sumana to be admitted to the bar. Yet broadening the where and when of the matter, by looking beyond the official archive, one can see that this was not the end to the case at all. Although a majority of the Supreme Court affirmed Venerable Sumana's rights to apply to the bar, ultimately negative public attention and media surrounding the case may have swayed things in the opposite direction. When, after winning his case, Venerable Sumana returned to the Supreme Court to take his oaths as a lawyer, the same bench that permitted his application now denied him entrance on account of what he was wearing. Even if a monk could be admitted to the bar, the Chief Justice asserted, he must wear a suit, not a saffron robe. This, it seems, was the more consequential outcome of the Venerable Sumana case, the more revealing evidence of law's life in the world, and the distance between its clear black letters and its complex social impacts. And this brings me to the last question, which is the trickiest. It is the why of law. Asked as an insider question, through the frame of the headnote, the question of why elicits a jurisprudential answer. It calls for ratio juris, the legal thinking of a judge. Yet, working as scholars of law, rather than professionals, allows us to ask different why questions. Those questions might have a historical focus. Why was the law passed at this particular time and not that? Why did petitioners bring the case sooner rather than later? The question might have a political focus. Why did a particular political group choose this project of legal reform and this person to lead it? Or perhaps it could have a normative focus. Why do certain forms of inequality or injustice persist, even in the face of laws that purport to fix them? Finding the right why question is, in many ways, what distinguishes your work as scholars from your work as legal professionals, because it requires you to embody an opposite posture towards law from the one that you're required to inhabit when representing clients or judging cases. To ask these kinds of why questions, you must temporarily approach the law as though naive or even incredulous about its work. Genuinely curious and open to being surprised. You must put aside your duty to uphold the law and ask questions about how the law really works. That is, you must step outside of your role as an agent of law and think of yourself as an observer, an outsider to law. In this sense, there are deep similarities between scholars of religion and scholars of law. Shifting focus from legal insider to outsider requires a similar mental leap to the scholar of religion who, although a believer at home, must act as a skeptic in the office in order to scientifically observe religion in the world. At its best, I would suggest this scholarly approach to law, this act of occasionally viewing it from the outside, of bracketing off one's faith in legal procedures, can complement and strengthen your work as professionals of law. Observing law in the world can help improve legal design and bring into clearer focus the long-term goals of justice, cohesion, and equality that can be easily overlooked in the day-to-day administration of law. To be a scholar of law does not require you to give up on advocacy, but only to be mindful of the significant epistemological gap between activism and observation. If I can leave you with one thing today, it is an invitation, both to you as persons and to you as an institution. As persons, I want to invite you, to encourage you, to broaden the questions you ask about law and rethink the facts that you think might be important. I invite you to expand on the scope of the 5 Ws as you apply them to your work, to think more broadly about what law is, who engages with it, where and when it occurs and leaves its footprints, and why it does or does not do what we expect. I invite you to think of yourselves not only as legal professionals and insiders to law, but as socio-legal scholars who also attend to the outside of law, who observe its work in the world. I encourage you to complement your disciplined reading of statutes and cases with other types of readings, exploring law's many footprints as they appear in politics, literature, art, and other forms of popular and political culture. I invite you to experiment with new forms of research, interviews, ethnography, surveys, and focus groups, to try new things and sometimes fail, as I did and do many times in my own research. And I extend to you another invitation to you as an institution, as the Faculty of Law at the University of Colombo, a place that has been foundational to the study of law and society in Sri Lanka, and in whose hands the future of Sri Lankan legal education largely rests. I invite you as an institution to take additional steps in fostering interdisciplinary scholarship on law as a way to advance both professional and scholarly goals. Minimally, this might mean crossing the campus a bit more to work closely with your colleagues in sociology, politics, and yes, Buddhist studies. But let me also invite you to do something larger, such as the formation of a dedicated Center for Law and Society in the faculty itself. Having recently co-founded a center here, I can testify to the wonderful benefits of having a place, even a virtual place, on a website, for expanding our questions about law as a larger interdisciplinary scholarly community. Perhaps we might even think of this in a collective way, linking our own work in Aotearoa, New Zealand, with your important work in Sri Lanka. No matter what comes of this talk and these invitations, please know that I am extremely grateful and very honored to have had this opportunity to share these thoughts with you. And I want to thank you as persons and as an institution for giving me a chance to be part of this very important conference. Bahoma Stuti and Roma Nandri. Thank you very much for your time.
Thank you so very much, Professor Chantal. We now have the presentation of a token of appreciation to our keynote speaker, this time by our chief guest today, Honorable Chief Justice of Sri Lanka President's Council, Mr. Jayantha Jayasuriya. I would also like to apologize for the slight technical glitch we had earlier. Unfortunately, despite converting so much to Zoom, we're still plagued with technical glitches and things that ought to be so straightforward, like tokens of appreciation. So with that in mind, and with my fingers crossed, it is now time for the presentation of the token. Once again, to both our chief guest and our keynote speaker today, our heartfelt gratitude for being with us here today. And we would also like to take a moment to present a token of appreciation to the
conclude the inaugural ceremony of the annual research symposium of the Faculty of Law. by extending a I'm extremely sorry. Is there a technical issue?
Now it's okay, madam.
Right, okay, thank you, thank you. A very good morning. Our chief guest today, the Honorable Chief Justice, Mr. Jayanta Jayasuriya, President Council, our distinguished keynote speaker, Professor Benjamin Shankar, Professor of Buddhism, Asian Religions, Co-Director, Otago Center for Law and Society, the Attorney General, the Honorable Judges of the Supreme Court and the Court of Appeal, Honorable Judges of the High Courts, Vice Chancellor, University of Colombo, Senior Professor Chandrika Vijayaratne, respected invitees, ladies and gentlemen, dear students, it's my honor and privilege to conclude the inaugural ceremony of the Annual Research Symposium of the Faculty of Law by extending a vote of thanks to all of you for joining this virtual event today. May I first and foremost express our thanks and deep appreciation to all of you for being with us today. At the outset, I would like to place on record our sincere thanks and deep appreciation to His Lordship, Honorable Chief Justice, Mr. Jayanta Jayasuriya, President Council, whose presence confirms the importance of this symposium. Sir, thank you very much for honoring us with taking the time off from your busy schedule to be with us today. I would like to express my gratitude to our erudite keynote speaker, Professor Benjamin Shankar. It gives us great pleasure, privilege to have him as our keynote speaker today. Sir, on behalf of the Faculty of Law, I would like to express my heartfelt gratitude to you for accepting our invitation and honoring us with a keynote speech for this symposium, despite your numerous and demanding national and international assignments. So thank you very much for your excellent speech. Thank you so much for sharing such wonderful thoughts with us on Buddhist law, general and special laws of Sri Lanka, constitutional law, and other related matters, especially on Katikavata and various aspects of Buddha Shasana. I'm certain that all of us here benefited from your wealth of knowledge, expertise, and experience. You produced one of the most memorable morning for us. My enormous respect to you, sir. Also, I would like to take this opportunity to express our sincere thanks to our guest of honor, our Vice Chancellor, who, despite her numerous and rather tight schedule, has found time to grace this occasion with her gracious presence. Madam, Faculty of Law is greatly honored and privileged to have you with us today, and we are immensely encouraged by your presence. Madam, I wish to recognize your encouragement and guidance in organizing this symposium and your support to the Faculty of Law in all these endeavors. Thank you very much, Madam. I would wish to express our profound gratitude and appreciation to all our distinguished invitees, the Honorable Attorney General, the Honorable Judges of the Supreme Court and the Court of Appeal, Honorable Judges of the High Courts, Senior Counsels, President Councils, distinguished legal luminaries, members of the Council, University of Colombo, Deans of Faculties, former Deans of Faculty of Law, emeritus professors, academic and administrative staff of the University of Colombo, and other law teaching institutes for accepting our invitation to join this virtual event with us. We all experience an unprecedented situation and have had to go through an unrelenting crisis of the global COVID-19 pandemic. We are not yet able to meet in person. However, I do believe we need to move forward. My deep regards and many thanks to our distinguished panelists for joining us. Madam and sir, I look forward to hearing your discussions and learning from your insights. The theme of this year's symposium is impactful research through an interdisciplinary approach. The interdisciplinary refers to knowledge that spans multiple fields of study. In the field of law, interdisciplinary approach is vital. Law has seen dramatic changes in recent decades, and it has no boundaries and does not operate in a vacuum. It is a collaborative endeavor. Academic legal research has grown increasingly multidisciplinary. Legal academia has identified disciplines outside of law that are most typically entangled with legal issues. These subjects include, among others, economics, social sciences, and politics. This is significant because law regulates many aspects of society. Lawyers increasingly practice in highly specialized fields, requiring not only traditional legal education, but also specific tools and knowledge. Also, an increasing number of graduates do not practice law. They use their legal training to a variety of disciplines. It emphasizes the importance of legal education in so many spheres of society. Further, interdisciplinary research makes a significant contribution to the advancement of critical thinking and cognitive ability. The annual research symposium is perhaps the most important annual event which enables university academics to present their research findings for discussion and critique by peers and stakeholders, and to engage in healthy and beneficial debates about the relevance, correctness, and cogency of their findings. Academics play an important role in conducting research that aims to expose previously unexplored territory in their chosen discipline or fields. I wish to take this opportunity to express our profuse thanks to Professor Hewa Gamage, the Director, UCSC, and Dr. Samantha Mathara-Arachige, Coordinator, ADMTC of UCSC, and his team for providing us the technical support and the service for the online platform of our annual symposium. I'm really impressed both by the high level of interest and the large number of high-quality abstracts submitted by my colleagues of the Faculty of Law. This reflects their commitment to the teaching profession and educational developments. Also, I thank Professor Vasantha Seniviratne for taking steps to launch yet another Journal of International Law of the Department of Public and International Law. My deep regards and thanks to all of you. Further, I take this opportunity to acknowledge the wholehearted and valuable support, encouragement given by our Dean, Dr. Sampath Pujjeva. This symposium would not have been possible without our Dean's support throughout the process. Thank you very much, Dean Sir, for your hour-to-hour guidance. You have been a constant source of inspiration to all of us. I'm equally grateful to our heads of departments of the Faculty of Law, Professor Vasantha Seniviratne, Mr. Menaka Haranka, and Udapadi Liyanage, for their enthusiastic and generous support. I say a humble thank you. I would like to take this opportunity to commend and thank my team, all members of the organizing committees of the symposium. Throughout the entire process of the symposium, Dr. Shamila Daud was by my side. Shamila, I greatly appreciate your diligent work and for the dedication and commitment you showed to make this occasion possible today. The chairpersons of the organizing committees, Professor A. Sarveswaran, Dr. Visakesa Chandrasekara, Mr. Hakim, Dr. Dilini Patirana, Ms. Chaturika, Ms. Yanitra Kumaragaru, they all gave their immense support in organizing this event. During The last month, the most calls I made and I received were from Dr. Chandrasekhara, who was in charge of arranging technical support for the event. Visa and also Chaturika, thank you so much for your amazing support. And please accept my sincere apologies for the constant annoyance. Department coordinators, Dr. Shamila Daud, Ms. Chaturika Apurugoda, and Ms. Tavini Nanayakara worked tirelessly and performed an excellent job of coordinating to ensure that communication and collaboration between the departments and the faculty was as seamless as possible. My special and hearty thanks go to Ms. Yanitra Kumaraguru for her great comparing despite her illness. I'm inspired by the work of my young colleagues of the Faculty of Law who served on various committees and provided enormous and unwavering support. Thank you so much, and please accept my apologies for not being able to thank you individually. My speech would not be complete if I do not acknowledge with gratitude the services provided by the non-academic staff headed by Deputy Registrar Mrs. Sunita Samaratugga. I honestly appreciate all of their diligent work, untiring efforts, and meticulous planning in organizing this event. They all worked smilingly, shoulder to shoulder, to make this symposium successful. In conclusion, I once again wish to thank you for being with us today. I wish that everyone who attends the symposium will find it to be a stimulating, academically rewarding, and enriching experience. I wish the symposium all success. Thank you.
Thank you very much, ma'am. Ladies and gentlemen, thank you once again for joining us at our inauguration ceremony today. We will now be moving into the technical sessions in breakout rooms. I do have a couple of announcements before we do that though. In moving into our technical sessions, they will be held at 3 separate breakout rooms, which you can find at the bottom of the screen. We do have a break, however. The private law session will start at 10:45 a.m. For the public international law session and the commercial law session will be starting at 11 a.m. So we do have that break. So you can log out, and it will also help us for capacity, to sort out a few capacity issues also, if you wouldn't mind logging out of this Zoom link and also logging back in. But that concludes our inauguration ceremony today. I hope you enjoy the technical sessions, and for those of you in commercial law, I will see you there. Thank you once again.
Thank you.